Hello students, today we are going to learn a new topic, citizenship. Book page number 171. First, what is citizen? A citizen is a member of a political community who enjoys the rights and assumes the duty of membership. See book page number 171. The word citizen is derived from the Latin word civis. It means resist of a city-state. The Constitution of India provides for a single and uniform citizenship for the whole of India. Articles 5 to 11 under Part 2 of the Constitution deal with the citizenship. Explanation. Citizenship is everything that has to do with it being a citizen or full member of a country. Citizens have the rights that are given by the country's government. For example, citizens have the right to do protected by a country's law. Citizenship is the status of the person recognized under the custom or law as being a legal member of the sovereign state and belonging to a nation. The conferment of a person as a citizen of India is governed by the Part 2 of the Constitution of India. The Constitution of India provides for a single and uniform citizenship for a whole of India. See book page 171, Citizenship Act of 1955. The Citizenship Act of 1955 provides for a acquisition and loss of citizenship after the commencement of the Constitution. This act has been amended so far 8 times. Originally, the Citizenship Act 1955 also provided for the Commonwealth citizenship, but this provision was repealed by the Citizenship Amendment Act 2003. Explanation. The Citizenship Act of 1955 provides for acquisition and loss of citizenship after the commencement of the constitutions. According to Article 5, all the people that were resident in India at the commencement of the constitution were citizens of India, as well as the people born in India. The President of India is termed the first citizen of India. An act to provide for the acquisition and loss of citizenship. The legislation related to this matter is the Citizenship Act of 1955, which has been amended by the Citizenship Amendment Act so far 9 times, not 8 times. See 1957, 1960, 1985, 1986, 1992, 2003, 2005, 2015 and the 9th amendment has been 2019 November 18. So this act has been amendment so far 9 times. See book page number 171, Acquisition of Citizenship. The Citizenship Act of 1955 prescribed 5 ways of acquiring citizenship via birth, descent, registration, naturalization and incorporation of territory. According to the Citizenship Act 1955, the citizenship could be acquired through any of the following methods. Explanation. Indian citizenship can be acquired by birth, descent, registration, naturalization and incorporation of territory. The conditions and procedures for the acquisition of Indian citizenship as per the provision of the Citizenship Act 1955. See book page number 171, first one, by birth. All persons born in India on or after January 26, 1950 are treated as citizens by birth. Explanation. First, a person born in India on or after 26 January 1950 but before 1st July 1987 is citizen of India by birth irrespective of the nationality of his parents. Second, a person born in India on or after 1st July 1987 but before 3rd December 2004 is considered citizen of India by birth if either of his parents is a citizen of India at the time of his birth. Third one, a person born in India on or after 3rd December 2004 is considered citizen of India by birth if both the parents are citizens of India or one of the parents is a citizen of India and the other is not an illegal migrant at the time of his birth. Second one, see page number 171, by descent. A person born outside India on or after January 26, 1950 shall be a citizen of India by descent if his father is a citizen of India at the time of his birth. Explanation. by descent. Section 4, first one, a person born outside India on or after January 26, 1950 is a citizen of India by descent if his father was a citizen of India by birth. Second, a person born outside India on or after December 10, 1992 but before December 3, 2004 if either of his parents was a citizen of India by them. Third one, if a person born outside India on or after December 3rd, 2004 has to be acquired citizenship, his parents have to declare that the minor does not hold a passport for other country and his birth is registered at an Indian consulate within 1 year of birth. Page number 171, third point, by registration. A person can acquire citizenship of India by registration with appreciated authority. Explanation. By registration. Citizenship can also be acquired by registration. First, a person of India origin who has been a resident of India for 7 years before applying for registration. Second, a person of Indian origin who is resident for any country outside with undivided India. Third, a person who is married to an Indian citizen and is ordinarily resident for 7 years before applying for registration. For the minor children of persons who are citizens of India. Book page number 171, fourth point, by naturalization. A foreigner can acquire Indian citizenship on application for naturalization to the government of India. Explanation. By naturalization, a person can acquire citizenship by naturalization if his ordinarily resides of Indian for 12 years. It is throughout 12 months preceding the date of application and 11 years in the aggregate and fulfill all qualifications in the third schedule for the Citizenship Act. Then the last one, page number 171, fifth one, by incorporation of territory. In the event of a certain territory being added to the territory of India, the government of India shall specify the persons of that territory who shall be citizen of India. Explanation. By incorporation of territory. Citizenship by incorporating territory is provided in the section 7 of the Act. If any territory became a part of India, the central government may be ordered notified the official gazette specifying the persons who shall be a citizen of India by reason of their connection with that territory, and those persons shall be citizens of India from the date to be specified in the order. See book page number 171, Laws of Citizenship. The Citizenship Act of 1955 prescribed 3 ways of losing citizenship, whether acquired under the Act or prior to if under the Constitution via renunciation, termination and deprivation. First one, it can be voluntarily renewed by a citizen. Explanation. The Citizenship Act 1955 also lays down the 3 modes by which an Indian citizenship were a citizen are the commencement of the Constitution or substitute to it many laws is citizenship. There are renunciation, termination and deprivation. First one, it can be voluntarily renewed by a citizen. Explanation. Renunciation is a voluntary act by which a person, after acquiring the citizenship of another country, gives up his name Indian citizenship. Second, page number 171, it can be terminated if a person acquires the citizenship of some other country. Explanation. Termination takes place by operation of law when Indian citizenship voluntarily acquires the citizenship of another country. He automatically ceases to be an Indian citizenship. Third point, the central government can deprive a naturalized citizen if it certified that the citizenship was acquired by fraud, false representation, or concealment of material facts, or induced in the trade with the enemy countries, or if the person has been sentenced to imprisonment for a period of 2 years. Explanation. Deprivation is a compulsory termination of a citizenship of India obtained by registration or naturalization. The citizenship is derived from the base of an order of the Government of India in case involving acquisition of Indian citizenship by fraud, false representation and concealment of material fact or being disloyal to the constitutions, etc. See book page number 171. Fundamental rights. The fundamental rights are enshrined in Part 3 of the Constitution from Articles 12 to 35. In this regard, the forwards of the Constitution derived inspiration from the Constitution of USA. Originally, the Constitution provided for 7 fundamental rights. At present, there are only 6 fundamental rights. Part 3 of the Constitution is rightly described as a Magna Charta of India. While fundamental rights are available to all persons, certain fundamental rights are available only to Indian citizenships. Explanation. Initially, the Constitution of India had 7 fundamental rights that are borrowed from the Constitution of the USA. But later on, right to property was abolished under now these are first 6 fundamental rights in force. Page number 172, right to equality. Article 14, equality before law. Explanation. Article 14 represents the idea of equality, which states that the state shall not deny to any person equality before the law or the equal protection from the laws within the territory of India. The equality before the law is guaranteed all without regard to race, color or nationality. Article 15. Prohibition of discrimination can grounds of religion, race, caste, sex or place of birth. Explanation. Article 15 states that the state shall not discriminate against any citizen on grounds only of religion, caste, sex, place of birth or any of them and could not be subject to any disability or liability and restriction or condition. Article 16. Equality of opportunity in matters of public employment. Explanation. Article 16 states that no citizen shall on grounds only of religion, race, caste, sex, descent, place of birth, resistance or any of them he illegal for other discriminated against in respect of any employment or office under the state. Page 172, Article 17, Abolition of Untouchability. Explanation. Article 17 abolished untouchability and forbids its practice in any form. Untouchability refers to a social practice that looks down upon certain oppressed classes solely on account of their birth and makes any discriminated against them on this ground. Book page number 172. Article 18, Abolition of titles except military and academic. Explanation. Article 18 abolishes all titles and prohibits the state to confer titles on anybody whether a citizen or a non-citizen. However, military and academic distinctions are accepted from this prohibition. Page number 172, Right to Freedom. Article 19. Freedom of speech and expression, assembly, association, movement, resistance and professional. Explanation. Explanation. Article 19. The right to freedom guaranteed to the citizens of India 6 fundamental freedoms. Freedom to speech, freedom to assembly, freedom to association, freedom to movement, freedom to resist and to settle, and freedom to profession, occupation, trade or business. Page 172, Article 20, Protection in respect of conviction for offence. Explanation. Article 20 provides protection against arbitrary and excessive punishment for excessive punishment for any person who commits an offence. This article cannot be suspended when during the emergency in operation under Article 19, 359. Article 21. Protection of life and personal liberty. Explanation. Article 21 states no person shall be deprived from his life or personal liberty except according to their procedure establishment by law. Article 21A. Right to elementary education. Explanation. The Constitution Act 2002 installed Article 21A is the Constitution of India to provide free and compulsory education for all children in the age group of 6 to 14. Page number 172. Article 22. Protection against arrest and detention in certain cases. Explanation. Article 22. Firstly, Article 22 guarantees the right of every person who is arrested to be informed of the causes of this arrest. Second, his right to consult and to be defended by a lawyer of his choice. Third, every person arrested and denied in custody shall be produced before the nearest magistrate within a period of 24 hours and shall be in continued custody only with his authority. Page number 172. Right against exploitation. Article 23. Prohibition of traffic in human being and forced labor. Explanation. Article 23 prohibits traffic in human being, women, children, beggars or other forced labor militant against human dignity. Article 24. Prohibition of employment of children in factories, etc. Article 24. Explanation. Prohibits employing children below the age of 14 years in any assessed profession. Page 172. Right to religion. Article 25. Freedom of conscience and free profession, practice and propagation of religion. Explanation. Article 25. Offer freedom of conscience and free profession of religious whereas Article 26. Freedom to manage religious affairs. Explanation. Article 26 helps to manage religious affairs which is subject to public order, morality and health every religion's domination or any section. Article 27. Freedom from payment of taxes for promotion of any religion. Explanation. Article 27 provides freedom not to pay taxes for religious expense on their promotion or maintenance of any particular religious. Page number 172. Article 20. Freedom from attending religious instruction or worship in certain educational institutions. Explanation. Article 28 prohibits religious instructions in educational institutions wholly maintained by the state. Page number 172. Fifth one. Cultural and educational rights. Article 29. Protection of language, script and cultural of minorities. Explanation. Article 29 provides protection of the interest of minorities. A minority community can effectively conserve its language, script or cultural by and through an educational institution. Article 30. Right of minorities to establish and administer educational institution. Explanation. Article 30 states that rights of minorities were based on religion or language to establish and administer educational institutions. Page 172. Right to constitutional remedies. Article 32. It allows individuals to seek redressal for the violation of their fundamental rights. Explanation. Rights in order to be meaningful must be enforceable and backed by remedies in case of violation. This article guarantees the right to move the Supreme Court by appreciated proceeding for the enforcement of fundamental rights and deals within the Supreme Court's power to issue order or writ from the enforcement of fundamental rights. Again, see page number 171, last para, right to constitutional remedies. Article 32. A writ is an order or command issued by a court in writing under its seal. It is the nature of command or prohibition for performing certain acts that are specified. The orders of the court, both the Supreme Court and the High Courts are empowered to issue 5 kinds of writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto, and certiorari. This is why the Supreme Court is called the guardian of the Constitution. According to Dr. Ambedkar, Article 32 is the heart and soul of the Constitution. First one, habeas corpus safeguards people from illegal arrest. Explanation. Habeas corpus literally means to have the body of. Via this with the court can case any person who has been denied or imprisoned to be physically brought before the court. Second one, mandamus. It provides the petitioner who requires legal help to get his work done by representative public authorities. Respective public authorities. Explanation. Mandamus means weak command. This writ is a command issued by courts to a public official by public body, corporation, interior court, tribunal or government asking them to perform their duty which they have refused to perform. Mandamus is also called a awakening call. See book page number 173, prohibition. It prohibits a subordinate court from acting beyond his jurisdiction. Explanation. The writ of prohibition means that the Supreme Court and High Courts may prohibit the lower courts such as special tribunals, magistrates, commissions and other judiciary officers who are doing something which are exceeded to their jurisdiction or acting contrary to the rule of natural justice. Page number warranto. It prevents aspiration of public office through illegal manner. Explanation. Quo warranto means by what warrant. This writ is issued to inquire into legally of the claim of a person or public office. It is not applicable for private office. See book page number 173, suspension of fundamental rights. When the President makes a proclamation of emergency under Article 352, the freedoms guaranteed under Article 19 are automatically suspended. The President can suspend other fundamental rights through specific orders. These orders must be approved by the Parliament, but he cannot suspend the freedoms given under Article 20 and 21 in respect of conviction for offence and protection of life and personal liberty respectively in any circumstance. Explanation. During natural emergency, all the basic freedoms guaranteed by Article 19 automatically get suspended. During emergency, President can suspend all other fundamental rights also except Article 20, protection in respect of conviction for offence, and Article 21, protection of life and personal liberty. Such suspensions need parliamentary approval. I summarize the topic. Citizenship. Citizenship is the status of a person recognized under the custom or law as being a legal member of sovereign state or belonging to a nation. Citizenship Act 1955 provides for acquisition under laws of citizenship. Indian citizenship can be acquired by birth, descent, registration, naturalization and incorporation of territory. The Citizenship Act of 1955 prescribes 3 ways of losing citizenship. They are renunciation, termination, and deprivation. Fundamental rights. There are 6 fundamental rights: right to equality, right to freedom, right against exploitation, right to religion, cultural and educational rights, right to constitutional remedies. The right to constitutional remedies, both the Supreme Court and the High Court have empowered to issue 5 kind of writs of habeas corpus, mandamus, prohibition, certiorio, and quo warranto. Suspension of fundamental rights. During the emergency, President can suspend all other fundamental rights also, except Article 20 and 21. Students, I hope you understood the topics. Students, you have to click the below link and do the assignment. Thank you.